what's interesting is this wasn't like our expert said that and the Crown expert said this is all ridiculous. Psilocybin doesn't do anything, but the Crown expert said that the acute effects of psilocybin include increased flexibility, cognitive flexibility, creativity, peace, transcendence, unity, deity encounters, social connectedness, and empathy. The Crown expert said that his team have a spiritual care chaplain as part of their psilocybin research team because these spiritual effects come up a lot. The Crown expert said the long-term effects of psilocybin include connectedness, reductions in anxiety, ability to help family friends, overall well-being, and a turning point that helps their overall well-being. So the effects are incredible, and the effects all tend to be positive effects and long-lasting effects.
Okay. Hi, everybody. I'm your host, Kyle, and this podcast is brought to you by the Multidisciplinary Association for Psychedelic Studies Canada, or MAPS Canada. As MAPS Canada moves forward, becoming the leading source for information, resources, and advocacy in psychedelic medicine, we recognize the evolving nature of scientific knowledge. This podcast is for educational and informational purposes only and does not constitute medical, legal, or professional advice. As we are recording this podcast in Toronto, I would also like to acknowledge I'm on the traditional territory of the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people, and that this land is covered by Treaty 13. So I'm here today with our guest, Paul Lewin. Paul is a lawyer in Toronto who has litigated drug cases and consulted on drug matters across Canada for over 30 years. He practices with Lewin and Segura LLP and Cannabis and Psychedelics Law Group LLP. His focus concerns matters related to cannabis and psychedelics. Paul has advised doctors, therapists, nurses, patients, businesses, politicians, teachers, the police, and other lawyers on cannabis and psychedelic law in Canada. Paul has spoken at cannabis and psychedelic events, lectured at universities, and been interviewed in the media dozens of times about cannabis and psychedelics. Paul has spearheaded advocacy campaigns across the country and lobbied politicians at all levels of government. Today, we are here to talk about the relationship between psilocybin and the right of freedom of thought, and a particular court case that he was recently involved in. I would also like to note that Paul is fundraising so that he can appeal his verdict of the case. There will be an email or link in the description if you are able to donate to this important cause. I'd like to start with a few basic questions for you, Paul, to situate this topic and your case. So my first grouping of questions is, what is freedom of thought? How is it different from freedom of religion, belief, or opinion? How is it protected in Canada? What charter right is freedom of thought covered under? And is there any existing case law regarding freedom of thought?
So freedom of thought is the charter right. It's under Section 2B of the charter, which specifically protects everyone, provides that everyone has freedom of thought, belief, opinion, and expression, including freedom of the press and other media communications. There is no law on freedom of thought. A couple of cases have just lightly touched upon it, but there really is no jurisprudence in this area. So when you ask what is freedom of thought, I can tell you the tests I put forward in the case and the tests that were applied by the judge, but there is no body of law on this. This is really all brand new.
Okay, if I were to ask what's the difference between opinion and thought, or belief and thought? Is there able to really any defining features of that?
Well, so opinion and belief haven't been litigated either. So it's the ones here that have been litigated a lot are expression and religion. And so there's a lot of big freedom of expression cases, and oftentimes someone will put forward, they'll be alleged to be doing something in contravention of the charter, whether there was a famous case, Keegstra, it was a white supremacist teacher who raised freedom of thought, but it was ultimately dealt with under freedom of expression. So nothing came of it under freedom of thought. There was a pedophile who was writing down his nasty thoughts. He raised freedom of thought, but it was ultimately dealt with as a freedom of expression case. So There's a lot on freedom of expression, a lot on freedom of religion, nothing on belief and opinion to my knowledge. I haven't done a deep dive on them, but to my knowledge, there's really nothing. So one would really be using common sense. Freedom of expression is unique because it's got an expressive quality. So it involves us communicating with the world, and religion, of course, involves a religious beliefs and manifesting those religious beliefs. So they have that. Though that's kind of a quick overview on how those different rights relate to each other and what there is out on those rights.
Okay, thank you for the explanation. I know freedom of thought is can be a little bit tricky to almost wrap your head around. I had read that in some of the global literature on it, that freedom of thought is considered more of a foundational right, in the sense that religion, opinion, expression, they all stem from freedom of thought. So yeah, just an interesting tidbit. What is a freedom of thought tool, and what freedom of thought tools should be protected and which maybe shouldn't be?
So a freedom of thought tool is something that allows one to experience freedom of thought in a more fulsome manner. And there's all kinds of examples of this in our jurisprudence. A classic one might be the right to a passport, as that allows one to experience freedom of mobility in a more fulsome manner. And I've got a list of them here in a case in the Supreme Court of Canada, CBC versus New Brunswick. The Supreme Court said that freedom of the press encompassed not only the right to transmit the news, but also the right to gather the information. In effect, gathering the information is a freedom of the press tool that must be protected under the Charter. So it's something that allows one to experience, allows us to experience thought in a more fulsome manner. And then you also ask what tools should be protected. And that really takes me to my test that I put forward to the court. As this has never been litigated, I really had to invent a test that had to be reasonable. So this is what I say. A freedom of thought tool, in order to be protected, must be reasonably, and when I say reasonably, that's viewed objectively or empirically. You can't just say, listen, I think breakfast cereal is a freedom of thought tool because I just have a wonderful day. I think so clearly when I have my special breakfast cereal. It's got to be empirically proven that this is really enhancing thought. It can't be just something that you assert. And seriously used for freedom of thought purposes. And I would compare this to what I think is a classic freedom of thought tool, and that would be a philosophy book. And you might not know exactly what you're going to think when you read it, but it's reasonable to use it for freedom of thought purposes. The requirement that it be reasonably or empirically used for thought purposes avoids people claiming something that, in fact, its connection to thought is limited. I gave the example of cereal. If we're thinking of a different type of book, perhaps a Stephen King book, which might cause you to have some imaginative thoughts, might stir your creativity a little bit, but it's not empirically connected to thought, and it certainly isn't seriously used for thought. So anyway, that's the definition that I put forward.
Okay, thank you very much. So now my next question is, what impact does psilocybin or magic mushrooms generally have on?
So we had an amazing and extraordinary evidentiary record. We had the great Professor David Nutt from Imperial College, probably the leading psilocybin expert in the world. And I'll tell you about some of the evidence that he gave in the case. He said that the vast majority of people who use psilocybin get a sense in which they are more connected either to themselves, to other people, or to nature. He said it's very common for a psilocybin experience to include feelings of unity or understanding of a greater being or a greater presence or something beyond the human psyche. Psilocybin induces changes in consciousness that tend to go hand in hand with changes in spiritual feeling and mysticism. And actually, those spiritual benefits are predictive of later mental health benefits, which was not just Professor Nutt's evidence, but also the Crown's experts' evidence. It's very common for people who have used psilocybin to develop new values or perspectives. The memory of the spiritual or mystical or religious experience persists forever, which makes perfect sense. When we have a deep, profound experience, that's not something that just goes away. That's with us forever. He stated that it's very common for a person who uses psilocybin to develop new values or perspectives. He said that people who have had that spiritual experience, as I said, tend to report themselves as being more spiritual ever after. He said that psilocybin increases cognitive flexibility. The judge accepted that. He said that psilocybin, people who, actually, my other expert, as well as Professor Nutt, Professor Zachary Walsh, said that people consistently rank psilocybin experiences as among the most meaningful experiences of their lives, both spiritually and personally. And what's interesting is this wasn't like our expert said that, and the Crown expert said this is all ridiculous. Psilocybin doesn't do anything, but the Crown expert said that the acute effects of psilocybin include increased flexibility, cognitive flexibility, creativity, peace, transcendence, unity, deity encounters, social connectedness, and empathy. The Crown expert said that his team have a spiritual care chaplain as part of their psilocybin research team because these spiritual effects come up a lot. The Crown expert said the long-term effects of psilocybin include connectedness, reductions in anxiety, ability to help family friends, overall well-being, and a turning point that helps their overall well-being. The Crown expert confirmed that mystical and spiritual experiences are common. All three psilocybin experts said that psilocybin causes deity encounters. So, put another way, people regularly meet God when they have a psilocybin experience. Does it happen every time? It does not. But is it reasonable to think that that might happen? Absolutely. And that alone is just to think about that for a moment, how huge that is, that I could have an experience in which I believe I've met God. So this is not a small thing. It's not like you feel good for a while or you feel a little creative for a while. This is huge and special. We had three civilian witnesses who all said that psilocybin was provided profoundly important thought-related benefits, and that it transformed their lives in significant ways. So the effects are incredible, and the effects all tend to be positive effects and long-lasting effects. So anyway, though you asked about the impact it has on thought. It has an incredible impact on thought, and not a neutral one. And charter rights, by the way, they are content neutral. That, like with freedom of expression, that white supremacist or that nasty pedophile, their expression attracts charter protection. So if the courts still say, hey, this is expression, these are charter rights, and this is super important. Well, shoot, if those guys are getting protection, how can the best of all thought not get protection?
It's an excellent point. Thank you very much. And so I guess to answer what impact does psilocybin generally have on thought, the answer is a lot. There's many, many thoughts, a lot of options. Brings me to my next question slightly, which is, what is the safety profile of psilocybin and what impact would that have on the Section 1 test? Maybe briefly explaining for our viewers what the Section 1 test is.
Right. That's a great question. Section 1, the idea of Section 1 is that you could contravene a charter right, and an example I often give is if there was a cannibalism religion. And so it's a real religion and they have a holy book and they're not making this up. It really is a religion. We have laws against cannibalism. They challenge those laws and a court says, well, look, this really is a religion. Those laws really are breaching their freedom of religion. But there's Section 1 allows the Crown to save the law. And so there's a test, and it's mostly based around proportionality. Is the response proportional to the issues they are concerned about? So this is how the test goes. It's a multi-step process. So you begin by asking if the purpose of the law is a pressing objective. And with the drug laws that we're challenging, the psilocybin drug laws that we're challenging, the purpose of the law is health and safety. And of course, we can't argue that that's not a pressing concern in society. So I conceded that the objective is a pressing one, and there's no denying that. Then the test moves on to whether the government has demonstrated that the prohibition is proportionate. And then here there's a 3-step process, and the government has to pass all 3 steps in order to save the law. So the 3 branches of this test are the rational connection test, the minimal impairment test, and the proportionality analysis. And they fail all 3. First, the rational connection requirement ensures that the measures adopted are carefully designed to achieve the objective in question. So the objective, health and safety. It must not be arbitrary or unfair or based on irrational considerations. The rational connection test requires the government to demonstrate on a civil standard that it's logical and reasonable to conclude the psilocybin prohibition will help bring about its objective of health and safety. And the evidence show, and it does not, and the evidence showed there's about 2.4 million people using psychedelics every year, and a large percent of that is psilocybin. So there is a huge amount of black market psilocybin use going on in Canada every year. And the evidence also shows that there's a whole bunch of ways that psilocybin, it's not addictive, and you're not going to overdose on it. The only risks there are is when people use it in a kind of knuckleheaded manner, and there's those in the psychedelic community know the precautions you should take. There should be some preparation. You shouldn't drink 10 beers before you do it. You shouldn't do things. Set and setting is a term we all know. Don't do it if you're in a state of if you just lost your job or you just got a cancer diagnosis. Maybe it can help later on, but if you're going through something traumatic, don't do it. Don't do it if you're on the side. You're going to be standing on the edge of a tall building. Don't do it. All kinds of just common sense things that we all agree. And so with these protections, the question here on step 1 is it safer if we have people doing it in a completely unregulated manner? Of course not. If the government allowed it in a regulated manner, it would be safer. There's really no way you can argue this. They fail section 1, the rational connection test. The law is not making it safer. It's not promoting health and safety. The second test, or the second branch of the section 1 test, is the minimal impairment test. And this asks whether the right is reasonably tailored, or put another way, is there a less harmful or less drastic means of achieving the objective? And you asked about the safety profile. Well, the judge found that it can be used safely. Now, this is not, this would involve supervision, and at a minimum, a facilitator, and probably some screening. So it's not, if we had, when we win, the first iteration of this will not be the Wild West. It'll be probably maybe a little bit like Oregon has, or maybe a less dramatic version of a clinical trial. Of course, you don't have someone with treatment-resistant depression, so you don't need all the protocols they have, but it would be probably supervised with some screening and somebody who knows what they're doing. There'd be some preparation, maybe some integration. But he said it can be done safely. So we know for sure they failed the minimum impairment test. So we already know they fail section 1, the government. They can't save this law because it could be done. You could allow freedom of thought in a safe manner. You don't jeopardize health and safety by allowing it. So that's a significant finding by the judge. So although there's lots of things I don't like about this decision, he said it can be done safely. And so that's huge. The third step is the They call it the proportionality analysis. It's all about proportionality, but this one's really about that, in which it directs the courts to balance the impact of the law on protected rights against the beneficial effect of the law. And this balancing is measured by the values underlying the charter. And it allows the court to stand back and determine on a normative basis whether a rights infringement is justified in a free and democratic society. And when they say on a normative basis, they're saying, what are the values in Canadian society? How, if we apply this in Canadian society, would we say we really got to prohibit this? Like, just as the cannibalism absolutely fails. And their best arguments are, well, it might cause some risk. It might come with some risk. But we know in Canadian society that we allow other I shouldn't call it recreational because this is freedom of thought, but other substances that are used for recreational purposes like cannabis and alcohol and cigarettes. Professor David Nutt talked about the multi-criteria decision analysis, which has been widely used all around the world, which ranks all the recreationally used drugs, about 20 to 25 drugs. Psilocybin consists, and it's not just him. Many experts have used a version of this MCDA, and psilocybin is consistently at the very bottom of the list, way below cigarettes, way below cannabis, and way, way, way below alcohol, which is actually often ends up at the very worst of them all. So we allow these things. We allow sports where people can get concussions or break their legs. But it enriches our lives. We allow travel, even though there's a lot of car accidents on the road, and sometimes there's planes crash, sometimes trains crash. There's lots of things that can go wrong. We allow that. We allow medications, many of which, like Oxycontin, we had evidence, by the way, about all the terrible things that commonly prescribed drugs do. And we say, you know what, if there's a chance this is going to make you better, even though there's some risks, we're going to let you try it. So looking at Canadian values, applying our values, looking at the law on a normative basis, they fail. This is absolutely would be allowed, but we don't even have to look at branches 1 and 3. They lose under number 2. The judge found that in effect.
Okay, I mean, those are some great arguments, and I am convinced. So you kind of answered a little bit, but would this differ from other psychoactive substances that are currently illegal? So would cocaine or methamphetamine be considered a freedom of thought tool under your arguments?
That's actually an important question because I think some people think there's some sort of slippery slope here where, like, 2 years from now, I'm going to be saying, cocaine, you're another freedom of thought tool. Even if one could establish that it was a freedom of thought tool, I don't think you would. But let's just assume, because we don't know what the test is, let's assume you can establish that something, cocaine or methamphetamine or heroin, these are all going to absolutely fail the Section 1 test that I was just talking about. That cocaine causes heart attacks and addiction, and there is no safe way to use it. And so the government would easily, this will be a slam dunk under Section 1, that no one's getting access to any of these hard drugs, the drugs we think of as hard drugs. This argument really only works with psychedelics. It doesn't apply to any other drugs. They won't become legal.
Okay, that makes sense to me. Okay, so I'd like to ask you a question, and you just tell me generally the information that you can. So what can you tell me about the case that you recently went through? Whatever you feel comfortable describing.
Sure. So the accused in the matter, his name is Samer Akila. He was, the allegations are against him were that he was a spokesperson for a Fun Guys mushroom store in London, Ontario. So he was charged with possession for the purpose of trafficking. He did an interview with CTV in which he was alone in the store. So he had knowledge and control of the substances in the store, which is, and they weren't for his personal consumption. So trafficking was made out, I think in the most modest of manners, but it was made out. He's very passionate about what psilocybin can do. And he felt very strongly about challenging the law. So that's now Mr. Akila is now in Egypt. He was concerned for his safety and he had to leave the country. He is not in a financial position to fund the case. He has done a lot for the case, so it's not like and this isn't really about him, really. Like a charter challenge is always about the law. It's not about the person and the facts. Really, there's a separate analysis that happens after the constitutional challenge to see if it even applies to him. Supreme Court of Canada said, you know what, anyone can bring a charter challenge, but whether you get benefits from it's a different matter. So anyway, it's not about him, but he is no longer able to continue it. If I was using a football analogy, it's like the ball has been taken down to like the 50-yard line. If we started on the 20-yard line, maybe it's on the other team's 40-yard line, but we have to continue it forward. And that's why the appeal is so important, because a lot has happened and a lot of good things. Even though the judge ruled against us, we have this amazing evidentiary record that's not going to evaporate. We have that, and that's what the Court of Appeal will look at. So anyway, that's he was the gentleman charged.
Okay, thank you. You had already brought up a few of the people involved in the case as witnesses that were brought forth, Professor Nutt and Professor Walsh. Is there anything else you can tell me about any other witnesses that were called to testify, either for the Crown or for the applicant?
Hey, we hope you're enjoying the podcast so far. Now, if you want to support and become part of the psychedelic movement, feel free to donate to MAPS Canada at the link in the description below. Thank you for helping our mission to support equitable access to legal and regulated psychedelic medicines for all Canadians.
So we had Professor Nutt, who talked about psilocybin, absolutely amazing. Professor Walsh, who was also terrific. We also had an expert on what thought means. Professor Lucas Swain from Dartmouth University. He's a political science professor. Fascinating guy, and his evidence was absolutely fascinating. And we talked about many different scenarios. He talked about the philosophy book scenario and how that should be protected. He defined thought as mental activity. His evidence was absolutely amazing. He's a super interesting guy. We were blessed to have such high quality, because it's never been argued before. It's important that we provide the court with a full background about what we know about this thought. Like one of the first foundational cases on freedom of religion had put forward evidence about the history of religion and why it's important to protect religion. And so we felt we kind of had to do the same thing with thought, so they understand everything about thought. We had an amazing pharmacist from BC who does all kinds of great work with psychedelics, Ms. Diol. She gave evidence about all the different pharmaceutical drugs and the terrible things that they do. That's for the Section 1 context. And we had 3 civilian witnesses. I'm not going to name their names just for privacy purposes, but they had such powerful stories. I mean, one of them, I'd almost get misty-eyed listening to her story. It was so powerful, and she was so articulate in how she described it. So their stories were amazing, and their evidence was accepted by the judge. I don't know how you can accept that evidence and not find that psilocybin is a freedom of thought tool. We focused a lot on the expert evidence, but the civilian witness evidence was huge. It was super powerful. And, in advance of this stuff, I spoke to so many people who said, me too, I have had these experiences. And for a number of different reasons, we kept it at just 3. One of them was we thought we were going to have to fight to have witnesses testify remotely. And as it turned out, everyone was allowed to. I kind of probably would have liked to have had a larger list, but it might have meant flying people in from all over the place, which would have been problematic. So anyway, those are our witnesses. The Crown had a doctor, Dr. Joshua Rosenblatt, who does psilocybin studies. I don't think, and I have some issues with Dr. Rosenblatt's evidence, but really it's not like he also said it brings about freedom of thought benefits in effect. So it's not, he's the one who described his deity encounters and all kinds of other good things. So it's not like he was a huge problem. I didn't like his evidence, but it wasn't terrible. It supported what I was saying. And then they had 2 experts from Health Canada who talked about the special access program and Section 56 exemptions. So those were the experts, and it was really, I was blessed to be dealing with these subjects with these people. So it was a great pleasure.
Okay, thank you. Sounds very interesting. And it's interesting to note that even one of the Crown's witnesses brought forth evidence that almost worked towards your case. But yeah, anyway. Okay, so a question I had when I was preparing for this podcast with you was, why did you choose the freedom of thought argument in this case and not other arguments? Because I think there are other ways you could argue access to psilocybin. Why freedom of thought?
Well, I think like the beating heart of what makes psilocybin so special is what it does for thought. And it does these great things by not altering our chemistry it does some positive things in terms of like neuroplasticity, but mostly it allows us to think in wonderful new ways. We have great thoughts and they stick with us. We say, wow, like that's really special. The way I was thinking about maybe a family member who I hated. Some of the civilian witnesses talked about issues with family members and they were tormented by this. And then they felt love for the family member. And it was like a great relief for them to love their family member and say, you know what, they're just like me. We're not so different. And that sticks with you. It doesn't go away, having that, or feeling like, you know what, there is a God and that God wants me to love my fellow man and woman. And so that's not something that just goes away, that sticks with you. I have a wonderful thought and it stays with me and it's really special. So it just seems like it's all about thought is what it's about. I'll say this too. A lot of people in psychedelic circles will know this really is the cognitive liberty argument, which has been around for a while. It's never caught on in any countries. I mean, you could say in some ways legalization, like Oregon, really is about cognitive liberty or freedom of thought. But we have something special in Canada. We have a charter that the government has to comply with. So maybe in other countries you can say, wouldn't this be nice if we respected cognitive liberty? But in Canada, we can get a judge to force them to do something. So that's, and I will do one shout out. You asked about why I did this too. Actually, for me personally, this actually goes back to a former client and friend, Jerry Martin, who maybe some people might know from the cannabis community. And he's done a lot of things that were really out there. He's since passed away, and he struggled with addiction, and he tried to help people addicted to drugs, addicted to opioids. And we talked a lot about this and talked a lot about bringing this argument forward. So actually for me, and this kind of goes back a few years. So I want to honor Jerry Martin's memory, who's really been fighting the drug war for many, many years. And one could say it ultimately took him down. But that's why
Nice.
I gave my thought.
It's good. It's very noble reasons, and I agree. The rationale makes perfect sense. You had mentioned before that the judge applied a freedom of thought test that maybe was arbitrary or new. What was the freedom of thought test that the judge applied in your case?
Yeah, so this is really the reason we lost. If there's one single reason, it's the test he applied. So the judge found that the effects of psilocybin are unpredictable in that no particular outcome can be expected in a given case. And it is unpredictable, absolutely. But the judge, I believe, applied, that's really an ill-fitting test for a freedom of thought tool. And you mentioned a new test. It is a new test, but that's because we had nothing. Like we were all just inventing this for the first time, which is kind of a weird thing. It's a neat thing, but it is a weird thing. So he invented this test. I'm not faulting him for inventing it because he had to invent something. But it's a terrible test. The judge's test required that a freedom of thought tool, in order to be predictable or in order to be protected, must be predictable in that a particular effect can be expected. Those were his words, or that one will have a specific thought. The test does not work for a freedom of thought tool. One could never predict what specific thoughts a freedom of thought tool would cause one to think. even though it might be perfectly reasonable to use that tool for freedom of thought purposes. And I give I spoke earlier about the philosophy book. Well, if we apply that to the judge's test, if I read a book on a great philosopher such as John Stuart Mills, who actually came up in this case a number of times, when I read that book, I don't know in advance what I'm going to think. I might think this is a bunch of rubbish. It might cause me to be angry and hate freedoms, or I might more fully embrace freedoms, or I might not understand it and it does absolutely nothing for me. Or another freedom of thought tool that I often give the example of is a psychotherapist. So this is someone who's going to help us think better thoughts, but I don't know what I'm going to think during the session or after or a week after. There's so many different things that can happen. And any psychotherapist will tell you that. So to say that you have to be able to predict the thought in advance, well, every freedom of thought tool will fail. But that doesn't mean there's no such thing as a freedom of thought tool. It's a test designed to fail. And it's the nature of thought. And that's why my test, is it reasonable to use the tool for freedom of thought purposes? The philosophy book passes, the Stephen King book fails. So anyway, that's the real reason. The judge made some other mistakes, but I think that's really the reason why I lost, was this terrible test.
Okay. So besides for the freedom of thought test that the judge applied, was there anything else that the judge failed to recognize in this case?
There was. So the judge said that Professor Nutt, in support of his opinion on thought-related effects, cited 5 studies involving 160 patients. And that's not even remotely close to correct. And that came from an early document. Anyway, I'm not here to insult the judge, who was actually a smart man, and he was engaged. But some people have said to me, "Oh, the fix was in and you never had a chance." That wasn't the case. He was deeply engaged. I think he was just squeezed on time. But that is completely wrong. Professor Knight cited 20 studies involving 1,700 people. In addition, he testified that several hundred psilocybin studies, modern and pre-modern, have revealed thought-related effects. Also in support of his opinion on thought-related effects, he testified that every study that measured thought-related benefits showed that the majority had thought-related benefits. Every single time in history they looked at this, thought-related benefits were found. Professor Nutt, in support of his opinion on thought-related effects, testified about 2 large surveys about naturalistic psilocybin use involving about 2,400 people, which found significant increases in cognitive flexibility, mystical experience, well-being, and connectedness, similar to clinical studies. He also, in support of his opinion, said that those 2 surveys are similar to a large number of other surveys that other groups have done, including his team. He said, in support of his opinion, that there are several thousand ceremonies and retreats happening every weekend around the world in which there is a deliberate attempt to optimize the benefits, and that the experiences from these ceremonies have been consistently found in both surveys and observational studies as being positive and valuable, resulting in increased well-being, creative divergent thinking, cognitive flexibility, and mindfulness. Professor Nutt, in support of his opinion, gave extensive evidence about the physiological and psychological support for his assertion about that psilocybin produces thought-related benefits. In other words, he didn't just say, we keep finding this in studies, but he also explained what's going on in the brain and why people are feeling this way, which supports his evidence. Further still, in support of his opinion, he adopted 2 studies which cited 29 studies that were relevant to thought-related benefits. By adopting the content of the studies, that essentially became his evidence as well. And finally, in addition to the vast amount of evidence in support of his opinion, there were a whole bunch of other studies filed as exhibits which all corroborated his evidence. So to say that there were 5 studies with 160 patients is really, really not correct.
Okay, interesting. Do you think that the judge was hesitant to make any type of verdict that could overturn anything in the Controlled Drugs and Substances Act? Was he worried about like a slippery slope or opening a Pandora's box? If anything, would like to say that legalizing the use of psilocybin due to freedom of thought, that would be like he just couldn't do that on principle?
I don't think so. I don't think so. I
Okay.
think this judge, I have brought a lot of constitutional challenges in my time, and I have had judges like that who right off the hop, there's just negativity and they want me to fail. But this judge was not that. He was open-minded. He was engaged. He engaged seriously with the subject matter. He was a smart guy. He asked smart questions. It wasn't that at all. I think he just ran out of time. That he's a lower court judge, and it's just a meat grinder in lower court, where like day after day after day, they have like giant dockets of cases they have to plow through. And he gave himself a large amount of time to write the decision, but it's not like he's not doing anything during that time. He's got a giant slate of other cases. So I think that's what was behind it. I don't think he was afraid to do it. So, although I will say, when you talk about slippery slope, we talked about other drugs. The Crown did raise a lot the question of slippery slope, like what tool, when does it stop? Can someone say they're driving along the road and they see a stop sign and they say, this is interfering with my free thought and making me think negative thoughts, and I want all the stop signs taken down. So there was calibrating the right test was a big part of this, because thought is potentially very broad. Like a lot of things could be a freedom of thought tool. And that's why I wanted to have one that was kind of tough, not one that just allowed everything in.
So you had kind of already mentioned it, but so what positive findings did the judge recognize? So obviously, there's some things now documented that the judge found that may work towards making this argument again.
Yeah. So actually, there's two great findings. I already mentioned one, the safety. And I don't know if I call that a great find. It's a really important finding, but I don't know how you could not make that finding. But still, he said it. He could have avoided talking about it, and he didn't. He said, I find it can be safely consumed, which is amazing and does help me a lot going forward. There's another finding that was actually very important, and that's, he said, a Section 56 exemption is not practically available for freedom of thought. So Section 56, as a lot of people in psychedelics know, is an exemption. That's under the Controlled Drugs and Substances Act. So you can apply to the federal government for an exemption that would exempt you or a group of people from the application of some or all of the CDSA, the Controlled Drugs and Substances Act, which is really the law that prohibits doing, possessing, growing, selling, importing drugs. So that's the law that says you can't do anything if it involves drugs, but you can get these exemptions. And some of them are very routine. I'm sure some researchers think of that as a very routine exemption. What in constitutional challenges, it's very common for the Crown to say the law is fine because you can always apply for a Section 56 exemption. So if you really want to have some special usage that is pursuant to a charter right, then just apply to the just apply for an exemption. And there was a case about 15 years ago, PHS, in which the Supreme Court of Canada, in a very different context, in the supervised injection site case, said that Section 56 is a great idea. And it is a good idea, and it works in some ways, but it really doesn't work here. And he found it's just practically not available. There's a whole bunch of problems with it. One of the things that came out is one of the witnesses from Health Canada who attended. I was asking, how would you know if I was applying for a Section 56 exemption, because there's nothing in there saying it's available for these purposes. You'd never know. You'd have to really be a lawyer with a focus on these things or work at Health Canada to know this. And I said, how would I even know that I could apply for a Section 56 exemption? And one of the Crown witnesses was, well, we're not in the business of telling people how to get access to drugs. So I'm not too worried if no one can find access to section, which I loved in a way. I just wanted to bring out more of that. There were some implications that people could go to the black market. There was some, too, I'm saying, where are you going to get it? because actually you'd need an exemption from the Food and Drug Act and the Food and Drug Regulations to sell it. So where exactly are you going to get it? Even if you get the exemption, are you hoping it's going to fall out of the sky and land in your hand? Is that what you're hoping? Or because growing it, the evidence was accepted that it's actually unsafe to pick psilocybin if you're not a mycologist or don't really know your stuff. So where on earth are you going to get it? You can't be exempted from selling. And they kind of imply you should just go to the black market, which is astonishing that a government official is suggesting just get it from some mushroom dealer. Why don't you go to Fun Guys and get it? They have them. So anyway, that was an amazing ruling. That was a very important ruling, and that was something that kind of concerned me throughout the cases. I know they're going to raise it, and how's it going to play out? And it's really not available. Like, it's Section 56 is so many problems. Yeah, it's great if you're doing a clinical study and you just need some little, we just need a researcher to be able to possess it briefly. Yeah, you'll get that lickety split. But if you're doing something outside the box like this, good luck with that. So anyway, great. There are some great findings in here, which will make a huge difference on appeal.
Good. I'm glad. So you had also kind of mentioned this a little bit, but is there a better chance of challenging the constitutionality of this case in a higher level of court?
There is, absolutely. Because this judge, I mentioned, the lower court judge, it's just so much that we put on his plate. I filed written submissions that were probably around 100 pages long. The Crown had a factum that was 72 pages long, which is insane. There was a massive amount of evidence and submissions because it was all so new. Everybody wanted to play every angle, and just for a lower court judge to have such a massive amount of stuff on their plate is kind of unfair. I mean, they're a judge and that's their job, but just I know the system was probably loading them up. A court of appeal will have lots of time to do a deep dive on this, so it's a complete. This will get a serious hearing. And I got a serious hearing from top to bottom, except for the end. And that decision was not a serious decision, in my view. I don't mean to insult the judge. I think if given the time, he could have written a much better decision. I think it was time. But we will, at the Ontario Court of Appeal, they will hear us carefully. They will pay close attention to all the evidence. That's what they do. They do take the big, complicated cases. So.
Okay, so I have a big kind of one of my last questions here for you, but what are the implications if you win this case?
The implications are incredible. They're fantastic. That means that currently you're getting psilocybin special access program authorizations being dispensed with an eyedropper, in which I don't know what it is. Is it 50 people, just a tiny number a year, and suddenly all healthy Canadians will get access. So it'll go from about 50 people a year to 40 million a year will have legal access. It'll be subject to reasonable limits. So children won't get access. Probably if you have a psychotic disorder, you won't get access. There'll be a few other examples of people who won't get access. But the vast majority of healthy Canadians will be able to get access. It'll probably be at a facility, and it'll probably be licensed, like it'll be a licensed product that you'll be accessing. But everyone will be able to get it. It's the first iteration, and this will evolve, and soon there will be retreats run in a responsible manner in which you have a psychotherapist there, maybe you have a nurse there. There'll be a whole, but because it's such a perfect fit with nature. But they will have to make it legal. This isn't like lobbying a politician, and I hear people do that, and that's lovely. I got no faith in politicians. They'll say, yeah, you make some really good points. I'm really going to consider it. The government, this is not something that the government may consider and will think carefully about. They have to. And if they don't make it available for everybody, if they don't make, what's going to happen is their law will be unconstitutional. The prohibition on selling psilocybin and or possessing psilocybin will no longer be in effect. And they love their laws. So they won't allow that to happen. The psilocybin, and that's how we got medical cannabis, by the way, in the first place. That they were just loving putting people away for cannabis, and it was only because of our charter that we got. They were forced to. They were given a year to come up with a medical cannabis system. And on July 31st, 2001, the very last day of the year, they created the very first medical cannabis regulations, only because if they didn't, there'd be no law. So that's what's going to happen is everybody gets access for freedom of thought purposes, and it doesn't stop there because really it's about all psychedelics. So this will change everything forever. So it's not a small thing, it's a giant thing.
It's a very, very exciting case and very exciting implication. So my last question that I have for you is what do you need to move forward with the case?
So the amount of money that I'm seeking is 150 grand. It's not all for me. The amount that would be billed as my fees is 100 grand plus HST, which is 13 grand. There's some disbursements that I would have to spend. And that might sound like a lot, but I'm going to work on this. Like I will do everything I can to clear my schedule, and I will work on this like night and day. I will so completely commit myself to it that it'll end up being like $3 an hour. Like I will, and I feel like I can't ask for money unless I'm charging a reasonable amount. Like this can't be a great payday given the amount of time I'll put into this. If someone can only, individual donations are great, but if like somebody, a larger player can put forward a chunk of money, even if they can't do 150, if they could do a smaller amount, that helps. The payoff is so incredible. And if you can just help somewhat, if you know somebody who's a big player in psychedelics, this will, you get such bang for your buck. Studies are nice, but for a much smaller amount of money, you can make such a dramatic change to the law. So.
Okay, thank you. So is there anything you'd like to say about this topic we haven't covered?
Well, I guess I should note that I have a fairly tight timeline. So it is mid-January, so it actually was mid-December, and I have a little bit more time, but mid-January is when I have to file the notice of appeal. So it has to be started by that date, by mid-January. I can't remember the exact date, but it's mid-January. But that's my drop dead date. So it is all fairly pressing. So.
Okay. Well, I just wanted to thank you so much for volunteering your time and joining our podcast. And I want to wish you best of luck in this case and any of your future cases. And I know everyone in our community really appreciates what you're doing and really would like to thank you for your hard work.
Well, thank you. And my thanks to MAPS for giving me this opportunity to let people know about it. My deep gratitude to MAPS.
You are welcome. And from MAPS Canada, we say goodbye to everyone, and we'll see you soon.